Is it possible to completely wipe your debt slate clean within the next 30 days by simply erasing debt that you currently have and be able to do it 100% legally? Well, the answer is yes. And in this video, I'm going to share with you exactly how to do it, under what circumstances it can be done, and which debts you can actually remove completely as if they never existed without paying a single dime. So I have a lot to cover in a very short period of time. So let's get into it. So what I'm going to share with you in this video is exactly how to validate debt using the 809 strategy. And so basically this happens in a two-fold, two-prong kind of process where, number one, if you have a debt collection agency trying to harass you and sending you letters stating that you owe a debt, then you definitely need to send what I call the 809 letter to them immediately within 30 days. And if you don't send a letter to them stating that the debt is not yours or that you're questioning the debt, then they will leave it on there and assume that you are agreeing to the fact that you owe this debt. So if you have been sent a letter from any debtor or collection agency whatsoever, you have 30 days to send them the 809 letter and demand verification of the debt. That's just a given. You have to do that, okay? Now, what about somebody who didn't send you a validation letter and they just are on your credit report and they're wanting money, but they haven't really fully enforced it at this point? Or you have an original creditor who basically is just lingering with a charge off on your credit report. Is there a way to get rid of this debt once and for all? And the answer is yes. And it's through the 809 debt validation letter that you should send to either the credit furnisher, the credit collection agency, with a certified card. It's one of those green cards that you get from the United States Postal Service. I recommend that you send it in a number 10 regular size envelope, or if you want to spend a little bit extra money, you can send it U.S. Postal Service priority in one of those cardboard envelopes. And you also want to make sure you get tracking with it. And basically this 809 letter demands that they show proof of the debt, and by federal law they have to show proof that the debt is yours. And this is harder for collection agencies to do. That's why I call collection agencies the low-hanging fruit, because many of them don't have something called a chain of title, which means that they can't prove that they actually purchased the debt from the original credit furnisher. And a lot of people don't know this. They don't know the behind the scenes on exactly how the relationship works between an original credit furnisher and a debt collection agency that typically buys, big swaths of debt from a credit furnisher or a bank, for example. And part of that agreement means that the credit furnisher, the original debtor, does not provide any contracts or any agreements that you, the consumer, would have had with them. Further, even if they did provide those agreements, the agreement is with you, the original, and the original credit furnisher. So say, for example, that credit furnisher is Capital One Bank, and you would have maybe had an agreement directly with Capital One Bank, but when they sell off the debt after it's charged off to a different collection agency or debt collector, there is obviously no agreement that you have with this random debt collection agency that came into the picture. What a lot of people don't understand is when big banks sell off this debt in massive swaths of debt for pennies on the dollar, typically anywhere from 6 to 20 cents on the dollar of what's owed, there is no transfer of the contract over from the original bank or lender over to the debt collection agency. A lot of people assume that this is the case, that there is in fact some kind of agreement, and there's not. They're like, well, Monica, we all signed this contract that's in size 4 font that says that they have the right to reassign the debt. Well, that may or may not be the case, but they have to prove that in fact happened. And see, that's where everything starts to fall through the cracks. So what you think is true, all of a sudden is not true, because what ends up happening is that because everybody, and millions of people, probably you included, assume that this transfer actually legally took place, and in reality, you are not privy to the contract between the original debtor or bank or lender and the debt collection agency. They don't share that with you. Legally, they have to. Okay, so here's the part that a lot of people don't understand, and this is why a lot of consumers are screwed over time and time again, because they don't understand what the law is and how they fit into the law. So you have the right to see this contract between the original debtor or credit furnisher and the collection agency to see how it transferred title, where the chain of title occurred. And if they're unable or unwilling to provide that document, then according to what you see and what you know as a consumer is, oh, okay, there's some random collection agency that just plopped this negative debt on my credit report. But at the end of the day, let me tell you something. You don't actually have an agreement with them. Yes, you still have an agreement with the original credit furnisher when you opened up the credit card or the loan or whatever it is that you have, but you have the agreement with them, not with the new kid on the block that just showed up, the new collection agency. And so again, you're going to argue, well, Monica, in the fine print. Okay, you could do that all you want, and that's fine. And if that serves you, that's great. But I'm telling you what the federal law is. And the federal law says that you as a consumer have the right to see this contract or agreement to show how it transferred over between the original credit furnisher and the debt collection agency. And if they're unable to show proof of this, and if they're unable to show proof, this collection agency is unable to show proof of how they fit into the equation legally, then it must fall off your credit report upon your request. Again, I didn't make the federal laws, so because I'm the messenger telling you how this works, don't shoot the messenger, okay? I'm just simply telling you how the law works. Now, of course, I always tell people this because I always get in the comments, there'll be some trolls that'll be like, Monica, you should just tell these people to pay their bills. Yeah, okay, that's great. Some people can't pay their bills, okay? So God forbid, maybe you got into an accident. Maybe you lost your job and you thought you were able to find a new job, quickly and you were unable to. Or maybe you were in a coma in the hospital, you came out and you had, $250,000 or more in medical debt. Like, stuff happens in people's lives. I'm not here to judge you. I don't have the ability to judge you. There's only one entity in the sky that can judge you at the end of this. And if anybody else believes they can judge you or should judge you, they can't. Okay, we all know that they can't and they shouldn't. And so again, people will troll around saying, just pay your bills. That's great. And I'm so glad that some of you have had the ability to do that all your lives. But most of us who are living in today's day and age, in today's society, have had to go through some stuff, okay? Whether it's a loss of a job, like I said, some kind of medical issue, some other calamity that we were unable to forecast or see ahead of time. And so we end up in trouble sometimes, and we have the best of intent on trying to pay our bills, but sometimes something happens, right? And so this is for those of you, not the people that are true deadbeats. Now, there is such a thing as a true deadbeat. And a true deadbeat is somebody who goes out there knowingly, on purpose, goes out there to borrow money with the full intent ahead of time on not paying it back. That's considered in my book a fraud. You don't want to defraud banks or lenders intentionally. This is not for you, okay? I don't tell people these types of backdoor strategies for the intent and purposes of purposely screwing people over, because that's not what this intent is. This is for those of you that have gotten in trouble and you just didn't have a way to get out, okay? So the law is the law. You can slice it and dice it any which way you'd like. That's fine. Everybody has their prerogative and their right to do that. My job is to tell you that their obligation and responsibility as per federal law says the following, and that is, upon request and upon demand to any creditor, credit furnisher, or collection agency, they have to show proof that you owe them the debt, not somebody else, them, okay? That means that when a collection agency picks up a debt from an original credit furnisher, lender, or bank, you should be able to see that contract and that interaction. They're not going to be able to show you that. They're not going to show you that. That's the key to this whole thing. And so their next best bet then would be to show the original contract. Well, there's a problem with that too, because most of the time, number one, they don't even have the original contract from the original furnisher, whether it's a bank or lender. But number two, even if by some miraculous, they all of a sudden have the documentation, they have the contract, well, guess what? There's a problem with that contract, folks. Their name is no longer, it's nowhere on the contract. So yes, they have a contract, but it's almost like they went into somebody's office and stole a contract from some other bank or lender, and they're saying, oh, here's the original contract that you owe this other lender money. Okay, well, that's fine. Looks like you stole the contract from Capital One or some other bank. I don't see your name on this contract anywhere. Like, where is your name on this contract showing that I owe you, rando collection agency, money? And that's where the problem occurs. That's where everything falls apart. So the regular consumer does not have any wherewithal, bandwidth, or understanding of basic laws to understand you can stand up and fight for yourself, and you can actually win and have this debt permanently removed off your credit reports. Okay, you can. The law is the law. Federal law is federal law. Okay, so how does this work? So first and foremost, let's talk about your situation. There's obviously different situations that occur. Let's talk about the most common situation. And that is, you get a letter from a collection agency or debt collector that basically says you owe X amount of dollars and basically pay up or else kind of thing. And so you have 30 days to validate or deny the debt. So right away, whenever you get any of these notices in the mail, you want to send a special letter. It's an 809 validation, debt validation letter. You never admit to or deny the debt unless, of course, it straight up isn't yours. And then you absolutely have to deny the debt. But what you want to do is you want to send this letter and you want to basically say, by law, you have to show proof that I owe you this money because I am denying that I owe you the money. I do not know who you are, never heard of you as a collection agency, never did business with you, and certainly do not have a contract with you. So therefore, it is your federal law responsibility to show me proof that I owe you the debt. And the proof better be a signed contract or agreement from me and a statement of the goods or products that you sold me. Okay, and the total amount that you're claiming that I owe you based on all of the proof that you are showing that you you want me to assume that you have, which, by the way, they don't have, okay? And you need to show me proof of this, and you have 30 days to do it. If you cannot show me proof that this is my debt, then it needs to be removed off my credit reports immediately. And if it's not, then there will be federal legal repercussions for this, okay? The legal ramifications may or may not be a lawsuit against you for basically stating that I owe a debt that I don't, plus damaging my personal credit reports. So there's punitive damages ahead. So therefore, you either cough up the proof or you shut up and you take this off my credit report. Again, this is the law, folks. Don't shoot the messenger here, okay? This is the law, all right? So again, if you just received a letter from a creditor of any kind, don't just bury your head in the sand. Send the debt validation 809 letter, which will do two things. One, it will basically tell them to cease and desist all communication with you at the same time as demanding, number two, that they actually validate the debt. And so the validation needs to be a signed contract that you have with them, not with other creditor, not with original creditor, with them specifically. And they're not going to be able to provide this. Most of them will be able to provide a bunch of statements from some credit furnisher, maybe sometimes, or other, invoices or so and so forth. But again, it's almost as if they went into somebody else's office, stole a contract, stole some invoices, stole some statements, and basically turned around and presented it as if it's coming from them, knowing that the name of their collection agency is something else. And that's when you need to question it. Be like, okay, well, this says Capital One on it, or whatever the name of the creditor is, the original creditor. This says Capital One, but the name of your rando collection agency. I don't see rando collection agency anywhere on this original agreement. I don't see rando collection agency on any of these statements. I don't see that I purchased anything or signed any agreement or, a contractual obligation with rando collection agency. I don't see you on here anywhere. So now then you have to show me proof that you actually own this debt, because I don't have any agreement with you whatsoever that I know of or that I have knowledge of or that I signed whatsoever. Now be careful, because a lot of these random collection agencies will, number one, try to re-age the debt to start it over from day one. So you might have a 5-year-old debt that they're going to try to re-age. So never have a conversation with these people over the phone, because they record everything. And if you admit to the debt over the phone, it starts it from day one. If you pay them even $1 on a payment plan, it also starts it from day one. So you never want to admit to anything or start a payment plan unless you know for sure you want to follow through with it and complete the debt and pay it as you originally intended. And if that's the case, that's great. But if it's not, then that's not what you're going to be agreeing to. You're not going to be agreeing to the fact that you owe the debt. You're not going to be agreeing to any payment plan either. Otherwise, you start a new contract with rando collection agency. People ask me this all the time. Well, Monica, how do I get out of this deal that I made with the devil, basically, with Rando Collection Agency? It's like, you can't. You signed on the deal. You agreed to the legal obligation to pay over the phone or whatever, or in writing, and you started a payment plan, which means that you just re-aged your debt. You just screwed yourself, okay? So never follow through with any kind of commitment with random collection agency coming out of the woodwork if you're not fully prepared to complete the contract, because it's essentially a new contract that you have now with a new entity. Why else would they ask you to engage in a new contract with them if they felt really spectacular about the idea that they knew you owed the money and that they have you under their thumb? And the answer is they know that they don't have you under their thumb. Otherwise, they wouldn't ask you to re-engage and to admit to the debt, or, they wouldn't ask you to engage in a new contract or a new payment arrangement, because they are really wanting to put you over a barrel, and the only way they can do that is by starting a brand new contract with you from scratch, because they know they don't have a contract. See, that's the whole game here. That's the whole sham. So if you get the letter from them asking you to admit to or deny the debt, send the debt validation 609 letter, which will again tell them to buzz off, basically cease and desist all communication. And number two, prove that you can, show that you own this debt or that I owe you anything in writing. And if you can't prove this, then you need to cease and desist all communication, but you're not allowed to call me. You're not allowed to text me. You're not allowed to email me. The only thing you're allowed to do is by way of mail only. You only want everything in mail, physical mail. You can send me proof of this debt. Proof of this debt better damn well be a contract with your name on it. And if it's not, if it's just a statement or an invoice, that doesn't count. I can literally walk over to my desk over there and print out a QuickBooks invoice that says any random person owes me money. Any random person. So just because it's an invoice that I can print off of my computer does not make it so. Doesn't make it so. That doesn't make it that you owe me the money because I can print an invoice. Anybody can print an invoice, okay? What anybody cannot do is anybody cannot prove that you owe them the money based on a contractual agreement. I can tell you right now, you do not have a contract with these debt collection agencies. You just don't. Don't make them think that you do, because you do not. And the burden of proof is on them to prove that you owe them the money, okay? So please do not admit to anything over the phone. Don't talk to these people over the phone. They record everything. Don't ever admit to the debt. Don't ever start a payment plan unless you are willing and able to follow through with it to the bitter end, okay? And by the way, if you want to negotiate with your debt, by all means, please, if you have the money, pay your debt. You don't have to pay them the full balance, though. You can take 50% off, sometimes more. Remember, they paid 6 to 20 cents on the dollar for your debt. So if you're going to offer them 30% of the debt or even 50% of the debt, you're going to come out ahead. You're going to be able to get this off, this negative, glaring, thing that's pulling down your FICO score off your credit. Well, it's going to stay on there, but it's going to show, settled as agreed on there. But at least that's better than just a charge off. And it'll look better on your credit report. But again, negotiate. If you're planning on paying them, negotiate that sucker down to at least 50% off, maybe even 70% off. Don't offer to pay them the whole thing, especially if you don't have the money, right? So please note that these are your options. This is definitely the way that you need to follow through. So this is what needs to happen. If they send you a letter, you have 30 days to send them. I don't know who you are. You have 30 days to prove who you are and that you have a contract with me, and you need to send that certified mail, period. Okay? So that is the debt validation 809 letter. You can get it for free on my website at getdisputeletters.com or secretcreditletters.com. I'll have it down below. And you need to get that letter and send it out immediately. Don't chintz out. Don't get cheap. Don't not want to send it certified. Send it certified. Spend the extra money to do a certified trackable mail. And then they have 30 days to respond with a valid contract. Now, if they don't, or if they just send you a statement, that's not a valid contract. In the interim, what I recommend that you do is dispute it with Experian, Equifax, and TransUnion, the 3 major credit reporting bureaus, basically stating this debt is not valid. These individuals are not able to show proof that this is my debt. You can actually share with them a copy of the debt validation letter, which is the 809 letter, and a copy of the certified card showing that you sent it in. Of course, you're going to want to wait the 30 days. and just say, they did not send me valid proof of this debt. Whether they sent you or an invoice or not is neither here nor there. Just tell the credit reporting bureaus, no, I didn't receive any valid, information as per federal law, which includes but not limited to a valid contract showing that I've engaged in a business relationship with these people. None of the above. They have not sent this by way of, mail as per my request, and according to federal law, it now needs to be permanently removed from my credit report as if it never existed. Okay, so that's what you do when you can actually have these debts permanently removed. Now, what if you can pay some of the debt? Well, again, try to negotiate with them, but always negotiate in writing. Email is okay when you're negotiating, by the way, because that is, in fact, writing. However, do not do any negotiation over the phone, and do not pay a single dime of anything negotiated until you have a finalized agreement. So yes, I'm all on board with people paying their debts. So don't think that I'm not, and you can save your comments if you think that that's what I'm about. I'm not about that at all. I'm just trying to tell you what people do and do not owe, what collection agencies can and cannot do, and what the federal law is based on what your consumer rights are. And if you don't want to know your consumer rights, you can just simply shut this video off and never watch anything on my channel ever again. However, if you want to empower yourself and understand what they can and cannot do as per federal law, then obviously you're going to want to follow suit with what I have to tell you, okay? So letter goes to the credit collection agencies with the certified mail. You wait 30 calendar days, and if they don't send you a contract, which they're not going to be able to because they don't have a contract with you because you never signed a contract with them, then you send a copy of where they signed that certified card. You also send a copy of that debt validation 809 letter. By the way, very, very important. When you are communicating with the credit collection agencies, number one, never sign your letter with your legal signature. Just put a scribble of an initial or just maybe the first initial of your name, maybe your last initial of your name. Never, ever, ever sign with your legal name, because sometimes, and I've heard of this, some unscrupulous, some shady, mofo ass, collection agencies, what they'll do is they will lift your signature from your letter and apply it to some contract you never signed, okay? So do not provide any creditor or collection agency with your legal signature on any letter you mail to them. That's number one, and that's a rule. That's a hard, fast rule you should never break. Number two, when communicating with any creditor or collection agency, do not include a copy of your driver's license or 2 utility bills. That's only when you're communicating with the credit reporting bureaus, which again are Experian, Equifax, and TransUnion. So again, you're not going to include any ID. You're not going to include any utility bills proving where you live. You're not going to include your legal signature on a letter to the creditors or collection agencies, ever. You don't want to give them any extra fuel. I mean, I've had some dummies send, I can't believe that they do this, but I've had some dumb people actually put their social security number on there. Which, by the way, they probably already have anyway, because they at least got that in the swath of debt that they purchased from the original creditor. But sometimes people put their date of birth on there. They'll actually put, I don't know why people do this, but they'll put account information, sometimes a checking account information on there, because sometimes the debt collection agency will ask for this stuff over the phone. People are dumb enough to actually give it to people. I don't know. I don't know about you, but when somebody's calling me on the phone and they're asking me for my routing number and my checking account number, they're not getting any of that. Okay, click. They probably wouldn't even have gotten that far on the phone call with me at that point anyway. So again, when you're sending these debt validation, the 609 letter to the creditors or collection agencies, you just basically want the letter in the envelope that's not using your legal signature, and you want to be able to, send that certified. Send it certified trackable mail. It's going to cost you some extra money, but you need to do this step if you want to have this stuff permanently removed. Never ever include your original, your legal signature. Never ever include any identifying information. Even better, folks, if you don't have a post office box, go get one. It's not that expensive, or borrow a family member's. If you have a parent that has a P.O. box, or a sibling or an adult child that has a P.O. box, just simply have them go to the post office with you and add you onto their box. As long as you have an ID, they can add you onto that P.O. box, and use a P.O. box. Use a P.O. box when you're communicating with the creditors or collection agencies, all right? Because the less ammo they have, the better. Now, some of you always ask me, well, Monica, this doesn't mean that they won't sue you. Well, let me tell you what won't guarantee you not to get sued either. A lot of you have this harebrained idea that if you leave this on your credit reports, it's suddenly and miraculously going to mean that you're never going to get sued. Really? Do you honestly think that they're not going to want to get their money because, it's sitting on your credit report and ruining your credit? And the second you have it removed, they're going to come after you like, a ton of bricks and sue you? No, that's not really how life works. It's like you're trying to make two things that connect that don't connect. Anybody can sue you for anything in this country for any reason. Welcome to the United States of America. It's a highly litigious society. It's why attorneys get rich, okay? So what happens if the creditor decides to sue you? Well, again, it's not going to matter whether it stays on your credit report or not. That determines whether or not they actually come after you and sue you. But if it's a certain dollar amount and they feel like it's worthy of them suing you, like some collection agencies, they'll sue you for $2,000. Some collection agencies will wait until it's $8,000 or $10,000 and then they'll sue you. Just depends on the creditor or the collection agency that determines a lawsuit. I highly recommend you go to this website. It's neverloseincourt.com. I'll have it down below. And if you go to that website, the very moment you're served a lawsuit, do not file an answer, do not do anything until you watch what's going on and go to neverloseincourt.com. You're going to have to go through the course as quickly as possible. You're going to have to start filing motions to dismiss immediately. You don't want to put your head in the sand. You don't want to not show up to court. Please don't do that, because that guarantees a judgment against you, and that guarantees possibly wage garnishment and everything else that's going to make your life miserable, even liening real assets or real property. So not showing up to court is not an option. But what you should do before filing an answer is you should file a motion to dismiss if they didn't serve the paperwork correctly, which most of them don't because they just leave it on your doorstep, which is not legal, by the way. What you should do is file a motion to dismiss for improper service. That's the very first thing that Jurisdictionary teaches when you go to neverloseincourt.com. In fact, you can get their free Jurisdictionary Flowchart that shows you the flurry of motions you should start to file the very moment you're served a summons or a lawsuit to go to court. And the easiest low-hanging fruit for that is a motion to dismiss for improper service, which is a way that you can actually get these lawsuits thrown out immediately. And yes, you can file these motions on your own behalf, and you can actually start an account in most counties across the country for free. You can go online and go to your local county and actually start a free account with the courthouse. And you could upload these PDF documents or these filings to start fighting these lawsuits against you. So file a motion to dismiss for improper service. If that doesn't apply, if you were washing your car in your driveway and the process server served you and it was a fair and square process service, then you need to file other types of motions, like file a motion to dismiss for lack of standing, for not a chain of title. The collection agency didn't show proof of how they came into this debt. Since all they were able to show is a contract with the original credit furnisher, and you don't have a contract with them, then they need to show something called chain of title. And in many cases, there's no chain of title that's provided, which means that you can actually win on that basis. You could also file a motion to dismiss for improper party. So, for example, if you know you had a contract with the original debtor or the original bank or lender, they're not a party on the lawsuit. That's a problem. They're not a plaintiff on the lawsuit. That's a problem. So you're basically saying with that motion to dismiss that there's the wrong party on this lawsuit. There's rando collection agency who you don't have any contract agreement with, but the original debtor is not on there. So that's a problem, and file a motion to dismiss for improper party. So there's a lot of different motions to dismiss that you can file. Yes, a lot of courts will require you to go to mediation, and you can just sit there and say, I still have no idea who you are, rando. I have no idea. All I know is that the name of your company is called Rando Collection Agency, and I have no idea who you are. And so even if the court decides that they want to make you go through mediation, which a lot of times they will, you just sit there with your arms folded and you go, I have no idea who you are. You have failed to show any proof that you're even part of this at all, don't know who you are, don't have an agreement with you, and until you can show otherwise, I'll just sit here in the corner with my arms folded at this table until the judge allows me to go back in there and we can continue on with this court case. Period. That's how it works, okay? Now, what else? What other rights do you have? So say, for example, you do everything right. You send the 809 letter. The credit collection agency is unable to show proof of the debt. Maybe they don't send you anything at all. You send a dispute with Experian, Equifax, and TransUnion, so showing proof that you actually demanded proof of the debt from Rando Collection Agency and others, and they provided nothing and demanded them to take it off. and they still didn't take it off, so Experian, Equifax, and TransUnion still didn't take the debt off, now what do? The next step is called a method of verification or a MOVE letter. It's MOV. You can also get that for free at getdisputeletters.com or secretcreditletters.com down below. And you're looking for the MOV or the method of verification letter, because by law, upon your request, TransUnion, Equifax, and Experian has to show proof of how they did their investigation when you demanded that they take this off for it being inaccurate. And by the way, if you're ever wondering why you're disputing something on your credit reports, what the reason is, initially it's always something that never admits to or denies the debt. And the safest and easiest thing to always put on your disputes is inaccurate information that needs to be investigated. So inaccurate information. That's all you need to put for the reason of your dispute, unless of course it's straight across the board ID theft, in which case you would put not my account, okay? So that way the eOscar method can assign the appropriate digit code for your dispute. So if you're putting inaccurate information, that means, you're not admitting to or denying the debt. You don't want to screw yourself later by admitting to the debt or denying the debt, unless, like I said, you have identity theft and it's truly not your debt, in which case it would be not my debt. And so what you do is you basically say, Experian, Equifax, TransUnion, you need to show proof as per federal law how you did your investigation. And here, and there again, in the letter that I have for free at getdisputeletters.com or secretcreditletters.com, you can actually see exactly what all the legalese is, all of the cited case laws, all of the federal laws that are actually in that letter for you on your behalf. You could send that in, and then they have another 30 days to show proof of how they actually pulled off their investigation, if that makes sense. And so you just keep fighting and fighting and fighting until you get where you want to be. Don't curl up in the corner and start to cry and suck your thumb if anybody sues you or if anybody sends you a letter, or that all of this is scare tactic, because that's their only sales and marketing strategy as a credit collection agency, is to scare you, because they have no other way of getting you to pay, because they don't even have a legal bearing to get you to pay. And most consumers don't realize that. They see a letter from an attorney's office or something, so-and-so attorney at law, who's a credit, who, by the way, a lot of them actually do get into the debt collection business, because it's a fear tactic that they use, where they have their ESQ at the bottom of every letter, attorney at law, to scare people into paying. And it's a really good way of making money for attorneys who are probably, really bad at ambulance chasing. So they get into the debt collecting business because it's easy to use their attorney at law, when they, graduated last in their class at, ABC law school. And so this is a really good way for them to make money. All they have to use is their name and attorney at law to scare you into paying. And it works pretty much almost every single time, because people don't understand that lawyers also fall under the debt collection category, which means that they also have to abide by the same exact collection laws, and they have to also have the same kind of contracts and the same kind of agreements, and they have to show the same kind of proof as per federal law, just like any other debt collector out there. So please note, if you don't have the money to pay, if you don't have the ability to create some kind of reasonable payment plan that you're okay with, that you can afford, that ideally is 50 to 70% off of what the original debt is, and you don't want to engage in a new contractual agreement with them, then don't, okay? Then don't, and understand what your laws are, but also understand what you're potentially going up against as well. So for some of you, especially if it's a lower debt, like say it's less than $500, I always tell people, I'm like, if it's less than $500, go collect cans and turn them in, or sell some stuff on eBay on the side. Pay that $500 off. This is a little trick, by the way. Pay the $500 off, or maybe it's $100, whatever the collection is. If it's some low balance collection, pay it off, okay? Send in a money order. Don't send them anything as far as your checking account goes. Send them a money order, which is the best route to take. And then the very moment the money order is cashed, then you can dispute it with Experian, Equifax, and TransUnion, saying information inaccurate or incorrect, because it technically is, because they're showing a collection account which has been paid. Don't tell them it's been paid. Just say it's inaccurate information. And what will happen is Experian, Equifax, and TransUnion will send out to the debt collection company, hey, so-and-so says this is inaccurate, so what do you have to say for yourself? And because the amount was paid, a lot of these collection agencies simply do not respond. And the very moment that they don't respond, guess what? It falls off your credit as if it never existed, which is the ideal scenario, especially for debts that have been hanging on there as charge-offs or whatever forever. So if it's like really low balance stuff like that, and you can afford to pay it, just send them the check, wait till it clears, or send them the money order, wait till it clears, and then dispute it with Experian, Equifax, and TransUnion saying inaccurate information. It'll fall right off like it never existed. That's the perfect, best outcome you could possibly have. But if you don't have the money, then you have to think about the other alternatives. Like if you owe somebody, $8,000, $10,000, $12,000 or more, and you don't want to sign up for a payment plan that you can't afford, like so many of you are signing up for payment plans you can't afford. Why are you signing up for a payment plan that you know you're not going to be able to afford down the road? Like, oh, I just signed up for this payment plan. It's $500 a month and I can't afford it. Well, why did you sign up for it then? Because now you're in a new contractual agreement with this credit collections agency and you just screwed yourself because you just entered into an agreement with them, an agreement that did not formally exist before, okay? So understand your rights and know what you're doing, when you're doing it, and understand that if these people could truly provide proof that these debts were yours, then there would be very little to talk about. It would be like literally pay this, or else basically. But they can't do that, which is why they have to use fear tactics to try to bend the rule and try to bend the rules. A lot of them do bend the rules. They try to trick you into saying things over the phone to reset your debt or to make it seem like you owe them the money. Like, for example, this is a classic trick that they use where they'll call you on the phone and they'll get you to admit to the fact that you owe them the debt. It's a recorded line, by the way. And the very second they get you to admit it in a recording that you owe them the debt, that is actually considered a contract as per the law. So this is how they trick people. This is why you should never talk to these people on the phone. Just hang up the very moment that you're talking to a debt collector. Don't even answer any questions or just say, I dispute this debt. Click. And that's it, because that'll be recorded. So please note that they trick you into doing all kinds of things, including, well, why don't you just start paying this account just $1 just today, and then we'll talk about a really good, easy payment plan in the future. Well, that dollar reopens the debt and starts an agreement with them, an agreement again that did not formally exist before you started the business relationship with them. So understand that you do not have a business relationship with these debt collectors. You don't. You think you do. They want you to think that you do, but they know damn well you don't, okay? Understand the law, understand what you can do, and get that debt validation letter. It's called the 809 letter at my website, getdisputeletters.com or secretcreditletters.com, and understand what your rights are and be ready to fight. And you can actually fight, turn the tables, and win. And of course, God forbid, if you are sued, go to neverlosingcourt.com and make sure that you fight like hell. And you can, in many cases, as long as you professionally, submit your motions as per how the regulations are for that court, you in many cases can actually win and get out of this whole thing altogether. So one thing I wanted to mention, if you did not get my free book on my school account, school.com/Monica Main, I'm about to take it down. It's called Credit Millionaire. You can, once you're admitted into the group, you go to the classroom tab, look for Credit Millionaire. It's right there. But the reason I'm taking it down soon is because I have my new book. It's called Credit Millionaire 2.0. This is now available on Amazon right at this moment. I will soon be able to release the physical copy on my website, but it's available on Amazon on both Kindle as well as Audible. So if you wanted to listen to this or read this, you definitely can. It's on Amazon right now. This is a thicker version of Credit Millionaire. It actually talks a lot about the legalese, the stuff that I've been telling you about on my channel over the course of the last several months on exactly how to fight and win and get rid of this stuff off your credit reports using the most hardcore examples of the legal system that stacks in your favor as a consumer. And most people don't know that this stuff stacks in their favor as a consumer. They are out there flailing in the wind, not realizing that there's so many federal rights that are on your side that can help you fight debt and win, okay? So Credit Millionaire 2.0 not only talks about how to quickly fix your personal credit using the law as a consumer, but also shares with you exactly how to start building unsecured business credit that you can use, OPM or other people's money, to put into businesses, put into investments, to start building wealth as a legacy for both yourself and your family for the months, years, and generations to come. All right? Like this content, give me a nice thumbs up, subscribe to my channel, make sure you drop some comments down below. It helps me out a lot. This is Monica Main signing off, and I will see you in the next video.